Hi, everybody. I'm Caroline Fredrickson, again, the president of the American Constitution Society. Boy, it only gets better. Everything has been so great up till now. This panel is going to be really splendid. This is the minimum wage and maximum hours laws since the passage of the FLSA. So this is the history after the passage. And again, a quick housekeeping reminder. We know you want to get that CLE credit, so I'm going to tell you about it one more time. If you'd like to receive credit for this session, please see one of the staff members at the registration table. For those who haven't, who are just arriving, we have MCLE credit in California and Pennsylvania and pending in Virginia. With reciprocity depending on your home state bar. So you'll have to check that yourself. So this panel is going to build off the morning sessions by looking at how minimum wage and maximum hour laws under the current FLSA regime have been enforced or not enforced, as the case may be, at the federal, state, and local level since the law was passed. We have a truly expert group of people here to discuss that, and I'm going to only briefly introduce them before we start. We have ReNika Moore, who is the Labor Bureau Chief in the Office of the New York State Attorney General. And prior to joining the New York State Attorney General's office in 2015, she was the director of the Economic Justice Group at the NAACP Legal Defense and Educational Fund and an associate at Out and Golden, where she represented employees in wage and hour discrimination and sexual harassment actions. Next, we have Richard Schrager. Professor Schrager is the Pierre Bown Professor of Law at the University of Virginia School of Law. His scholarship focuses on the intersection of constitutional law and local government law, federalism, urban policy, and the constitutional and economic status of cities. A prolific writer, he's been published in the Harvard, Yale, Chicago, Virginia, and Michigan Law Reviews, among others, and is the author of City Power, Urban Governance in a Global Age, published by Oxford University Press. Moreover, and relevant for our conversation today, he is the co-author of a recent ACS issue brief entitled The Troubling Turn in State Preemption, The Assault on Progressive Cities and How Cities Can Respond. Next, we have Heidi Shierholz. Heidi is the senior economist and director of policy at the Economic Policy Institute, or EPI. She leads EPI's efforts to advance a worker-centered policy agenda, which includes a policy response team that tracks the Trump administration's wage and employment policies. Unfortunately, tracking them all downhill. From 2014 to 2017, Heidi served in the Obama administration as the chief economist at the Department of Labor, where she worked with Labor Secretary Tom Perez and other DOL leaders to boost workers' rights, expand wages and benefits, and increase workplace safety. And then, of course, we have David Weil, who we have just heard from, and I will not go completely over his biography again, since I just did that. And you know him well already. But suffice it to say, this is a great group to talk about the topic of the moment. So I'm going to start with ReNika, if that's okay, to give us a little bit of context. We talked about the Fair Labor Standards Act and how it came into being and how it really revolutionized the treatment of workers in the workplace. But how did states and localities respond after passage of the law? I imagine they didn't all embrace it. Did they think it was insufficient or over-inclusive?
Right, so I'm going to talk primarily about New York, but there was a story, and we heard earlier, in terms of the states that have not kind of taken the charge of the FLSA and raising the bar. I think in New York, a lot of that work, we heard about Frances Perkins, so the shirtwaist fire that led to a lot of revolutionary kind of analysis of workers and worker conditions in New York State started before the passage of the FLSA and then continued even after. And so there was, within the Northeast, you definitely saw worker mobilization, and you saw that there were child labor laws, there were minimum wage, maximum hour laws being passed. So there was already, I think, a pretty vibrant worker population and legislative movement to try to create these protections. And that continued after the Fair Labor Standards Act passage. And then what New York has done, and I think this has been true of a number of states, but there are definitely a tale of two paths with respect to how states and localities have taken the charge. And in New York, you saw that there was an overhaul of the administrative process, and you saw the raising of minimum wage and the expansion of protections allowed under the Fair Labor Standards Act. And so now in New York, you bring us to today where the statute of limitations goes back 6 years. So that's twice as long as the Fair Labor Standards Act. You see higher record keeping protections, wage notice protections to workers and what they're required to provide to workers. And so I think there was hand in hand with, we've talked about worker empowerment, there's a fair organization of workers and union presence in New York, and I think there's a really strong worker presence. And so in states where you see that, you've seen states really take that charge and run with it and be supportive. I'm sure there's another story to tell. I'm going to stick to New York in terms of states that have not been as receptive to the passage of the Fair Labor Standards Act and sort of what workers can do and what they can expect from their employers.
Well, since you opened that door, I think the rest of you are all very well versed, unfortunately, in mostly, well, I shouldn't say mostly. There have been a variety of responses in the states, and some of them have been positive. Some of the states have gone beyond the floor, have raised the minimum wage, have no tip credit, as we heard. Some of them are moving forward in other types of protections. And then, of course, some of them are moving backwards, even to the extent of preempting localities that are trying to do better. So, maybe I'll turn to you, Richard, since you just wrote this issue brief for us to sort of talk a little bit about what else is going on outside of New York.
Yeah, so I'm a bit of an imposter because I'm not a labor person. I'm a city person. And what we saw a number of years ago was that the minimum wage movement starts in cities, which is quite unusual. Lots of people would have been surprised by that. And lots of folks would have said, you can't raise the minimum wage in cities without the flight of capital outside of those boundaries. We have some mixed responses to that, but I think on the whole it's been quite successful locally. But what we've seen now in the last 5 years or so, it's been a little longer than that, but a real push for state level preemption of those kinds of laws, minimum wage, labor laws, employment, any kind. And a lot of what we're seeing are states considering blanket preemption laws, which just say all employment, all labor, all wage and hours legislation locally is preempted. And some of that's punitive preemption. Punitive preemption is when you take money away from localities that try to pass certain kinds of legislation. That includes lots of other things aside from labor law and employment law. But yeah, we're seeing the reaction to the local minimum wage movement was a preemption move by lots of states, and a significant number of states have now preempted local minimum wages.
I had to take a moment to talk about Birmingham for a second, just because that came up earlier and someone had asked me. I think where it is right now is on appeal to the 11th Circuit, but someone else may know that. I know that the city lost in the district court, but and I don't know if this comes up, how this plays out with the generally with preemption. But the argument in that case is one about the state constitution being adopted at a time during the Jim Crow, worst of the Jim Crow era, precisely to disenfranchise the more African-American urban population. And it strikes me that certainly an urban-rural kind of difference, and to the extent that plays into preemption, has that become one of the arguments that is being used?
So there are attempts to bring sort of equal protection claims, which is to say the state law preemption, to the extent it targets urban residents and disproportionately minority residents. One of the theories has been, well, this has a disparate impact. The problem with that, the difficulty of that, is you don't have intent, and under constitutional doctrine, it's very hard to win those kinds of cases. But I think there is that dynamic going on. What you're seeing are blue cities and red states. And red state legislatures, more conservative legislatures, are overriding local laws to the contrary. The blue cities are more heavily minorities, such as Birmingham, and they're more heavily have low wage workers. Although agricultural workers, right, are low wage too. So it's. I think there's some there could be some cross urban rural alliances created there, but in terms of state legislatures, this is a problem. And so equal protection is one response. I'm not sure it's one that's going to be successful, but it is one response.
So Heidi, I know API has done a lot of work around preemption, around state minimum wage increases or localities minimum wage increases. What are the trends that you are seeing?
Yeah, exactly what Richard said, that we're seeing red states coming out and stopping blue cities from being able to do what they want to do. And I think it's like this question of whether it's about disproportionate impact. Yes, if you have one low minimum wage, it's actually more of a burden in places that have higher cost of living. So that can be cities rather than rural areas. So there is that disproportionate impact there. But I also just think it's places that typically aren't raising the minimum wage, period, across the board in the state. And so the federal minimum wage, I'm so sad I missed the entire morning because I had another thing, so I'm sure this has been totally covered. But the federal minimum wage, it's more than 25% below where it was 50 years ago. And so when you're in a red state that is not increasing that, your lowest wage workers across the state, not just in cities that are getting preempted, are just seeing an erosion of their wages.
Well, ReNika, let me just ask you a little bit about, since New York is obviously a shining example, what were some of the things that were especially significant about New York that led to such strong protections, and sort of where in particular is New York stronger than the minimums that we see in place in the Fair Labor Standards Act?
Sure. So in New York, we have a combination in terms of how the wage and hour standards are set. So we obviously have the federal, there are state laws and regulations, and we also have wage boards that do look at by industry. They issue wage orders that set industry and minimum wage and requirements for different sectors of the workforce. And so I mentioned before, we have a higher statute of limitations. So our statute of limitations for wage claims, for record keeping, for notice requirements goes back 6 years. So there are very specific requirements because one of the things that we've noticed with workers, and I think this comes from like high worker organization and vocalization of understanding that what makes it hard for workers to get their wages back is that they don't know what they were supposed to be paid. And that employers use that sort of that black box of what your actual wages are as a way to not pay workers what they are supposed to be paid. So there are obligations to explain what the rate is, how a worker is to be paid. Is it by the piece? Is it by the hour? Is it by the week? And so that those are supposed to be provided in the form of a wage notice when a worker starts. And then in the pay stubs themselves, there's requirements about identifying who the employer is, what the address is, and just that sort of information in and of itself can really make it much easier for workers to get their money. And where we see violations are often because they're violations of these kind of technical requirements. And we've attached a fair amount of statutory penalties to those violations. And we recently filed a lawsuit against a car wash where there were hundreds of thousands of dollars of violations for these technical violations that are hugely important in being able to prove what the workers were supposed to be paid and when they worked. And so we have attached a great deal of importance to that kind of record-keeping requirements. So in addition, we've raised the minimum wage so that there are now like I literally keep a cheat sheet, 5 different minimum wage levels related to fast food workers. And the goal is that they will ultimately all be a $15 an hour minimum wage. But there's a leveling that's happening, and we're in the midst of that leveling. So it changes based on if you're in New York City versus Long Island, but the minimum wage is higher than the Fair Labor Standards Act. The OT requirements and sort of unlawful deductions, there's certain requirements related to that. So really across the board, I think New York has taken the charge and decided to provide as much enhanced requirements that allow workers to not just get the more money, but also to understand how violations happen and what are the ways that enforcement is hobbled.
I think it's so interesting what you have to say about the information piece, because that's certainly something that comes up a lot in the employment discrimination, particularly when women are subject to pay discrimination or people of color. If you don't know, it's pretty hard to know, right? And it's certainly if you don't know, how can you build a case? And so, in this context, I think information is everything, and it's one of the reasons I think it's a very hard-fought battle. But maybe you could talk a little bit, because I think this is really, really fascinating for those who are following the fast food industry fight in New York, the role of the wage board, because, thinking about, in the earlier panel, there was some discussion of the avoiding sort of wage boards in the Fair Labor Standards Act discussion because of the possibility of diluting minimum wage efforts and making exemptions and so forth. And here in New York, we have sort of the positive direction where the wage board actually moved forward. And so can you explain how that happened, and did it defy expectations?
Right. So it was definitely a messy fight, and there was a challenge to the wage order, but you had a mobilization of workers in the fast food sector. You had the Fight for 15. So there was a fair amount of pressure that was coming from workers themselves. And then there was, so the wage boards, there's sort of a commission. The governor issues a commission who gathers information, and then they then make a recommendation, and then the wage order is adopted. But what it did was it ultimately raised the water for all boats. I've totally mangled that expression. And so we will now have a general minimum wage of $15 for the entire state. But I think the wage board, I think there's an argument to be made about the specificity of the industries, but I think I think there's contrary arguments that in general, particularly in a place like New York City, like the standard of living is the same, and more than the jobs are different in terms of industry, they are alike in that people need the money to live. And so you do hear those counter arguments, and so what we do continue to have them, and we have them for a variety of different sectors, and I think it's largely a holdover from prior times, but on the whole, it actually has worked to move the entire workforce, where wage boards have adopted wage orders to lift the minimum wage.
So before we move on to some more specifics about the Fair Labor Standards Act, I'm just wondering, maybe this is primarily for Heidi, but also David, in terms of, showing examples like New York or other positive examples, what is your economic case? What are the benefits that come from having more protective laws in this area?
That's a good question. So it's a big question. What we know, and it actually loops into a broader question that's happening in the sort of amongst economists and amongst economic journalists right now. So, and just to sort of back up 2 steps, historically, economists had embedded in their thinking that the labor markets are essentially perfectly competitive. And what that means is that if you believe that labor markets are perfectly competitive, it means that any time you do something to strengthen a labor standard, it introduces inefficiency and it costs jobs. And so that's been a huge voice in pushing back against any kind of strengthening of these standards at the federal level, at the state level. Sort of, I'm an economist. Economists have been sort of a problem in this. And so, but one thing that we're seeing happening now is something of a softening of that. There is growing evidence that labor markets actually aren't, that a perfectly competitive labor market isn't actually a good approximation for what really is out there. And we're starting to see conversations, people acknowledging that employers actually have the power to set wages below a worker's productivity. They have the power to set wages below the value of the output that the employer actually provides for the firm. And so that, if you Google the word monopsony right now, you will see op-eds, articles everywhere. It's just absolutely everywhere. And I just want to put that aside for a second and just say,
can you spell it first?
Yeah. Monopsony. MONOPSONY. And did I get it right?
Yeah.
Monopsony. Okay. So wait, just on that word, don't try to think about if you heard in some Econ 101 class sometime that means a one company town. Don't just forget that definition is actually not useful. When you hear the word monopsony, just think of it as a catchphrase for think of it as a catchphrase for employer power of a variety of types. And so with this broader discussion of just this possibility that employers actually have some power out there, it gives economists who have a loud voice in all of this some space for thinking that labor standards, labor market institutions actually can improve job quality without wreaking havoc on the labor market, without causing huge inefficiencies and costing jobs. And so it's going to be a slow process, but you can see it starting to happen. And so I think that I can't actually remember what the original question was, but I think
economic benefits.
That okay. So it
was a great answer.
Yes. Okay. So I've always thought of the amazing economic benefits of these, but the important thing is if it permeates into the broader economic profession. It's not there yet, but we're starting to see softening. Correct me if I'm. You think that's a
No,
right?
I totally agree. And I mean, the only part I would add to that is the evidence suggests that. So we have had lots and lots of experiments now in raising minimum wages across all kinds of, both at the locality level and the state level. And there has been an abundance of very careful, cutting edge research on this. And the result of that research is the employment effects of the minimum wage increases we've seen across the country are minimal. That Econ 101, for the reasons Heidi describes, doesn't apply because labor markets are not perfectly functioning forces. They are filled with all kinds of grit, and there is an increasing presence, I agree, of employer power that distorts things. I would make one other point I think important, a different kind of political economy point on the whole question of localities and states setting minimum wage and different policies in terms of wage standards. You know, the person who named the institution I now work at, Louis Brandeis, you know, famously talked about states as the laboratories of democracy. And I think there's an interesting thing that happens when you have different states not only changing minimum wage standards, but also changing standards about what we find acceptable at the workplace. And that is, I think you can make an argument, it can bring things up. If you look at the federal minimum wage, when is the federal minimum wage, which has always been out of whack with the cost of living, what does it take for it to move up? Well, what happens is you get a significant number of states who start raising the wage significantly above the federal wage. At a certain point, the usually monolithic business lobby starts splitting apart because you have those businesses that exist in a multi-state world who start saying, this is getting really annoying. Why do I have to pay this wage here, this wage somewhere else? And so the coalition of the larger multi-state businesses starts breaking apart from the smaller locality-based businesses who are always the people most vociferously against any increase in the minimum wage. And that's when legislative change has historically happened at the federal level. If you look at how did the Family Medical Leave Act pass, there was increasing activity at the states that was doing something akin to family medical leave. How did the plant closing legislation, the Warren Act, pass? You had a lot of states implementing it there. I think the kinds of innovative thing we're seeing in paid leave now, in some of the, you know, with New York and California always in the forefront of changing the definitions of things like overtime. I think this political economy part of it is also really important to understand as a driver of overall change.
I mean, I think that's a really important point. And I think as the minimum wage has increased in different states, you've seen a number of red states do it through ballot initiative, even if the state legislature hasn't been willing to do it. Yeah. The population, it's such a strong and popular issue that people feel like there should be at least a minimum wage, if not a fair wage, and the minimum wage needs to be higher. And I think that then, you know, permeates out and people generally share that opinion. They put pressure on the legislatures and the legislatures pass something or there's ballot initiative. And then finally, Congress has got to start listening. So let me ask you now. I want to ask Richard, maybe and David, if you talk a little bit about this is getting more into the weeds, but the Fair Labor Standards Act is obviously a statute, but it's implemented by a whole bunch of regulations. In the face of a Trump administration, which, as Lynn Reinhardt mentioned earlier, is appointing judges with a decidedly deregulatory bent to dismantle the regulatory state, how much do we have to fear? That is, how much of our protections are statutory, and how much is in the regulation? How much, ultimately, how much discretion does this president have, Department of Labor, other implementing agencies, to undo these laws? And so how vulnerable are American workers?
Pretty vulnerable, I'd say. I mean, we've seen this, right? So it took a statute, right? We've talked about this. The tipping or the overtime, all those things are often a product of regulations, not a product of the statutes, unless you embed them. And so I think the executive has a lot of authority here, and a lot of the challenges to these things across lots of areas, environmental, et cetera, immigration, are going to be through the Administrative Procedures Act, right? There's going to be challenges to the processes because they're being pushed through very quickly, and so you need litigators who specialize in that, right, in the Procedure Act. So I think there's a lot of vulnerability there, and there's going to be a lot of you'd have to have a lot of administrative pushback.
Can I ask you also, just as you answer that question,
Yeah.
can you elaborate a little bit on the overtime rule? Because I think we've alluded to it a bunch, but I'm not sure everybody has it's not just giving more people overtime protections, but it's expanding the wage base. Maybe fill people in a little bit on where that is.
Sure. No. And I agree at the macro level that there certainly are big dangers, and the more judges that the Trump administration appoints, the more perilous the situation on all kinds of fronts. That being said, one of the many lessons I learned as wage and hour administrator is writing regulations is really hard and is a very fraught process, and is a process where the more all of the parties are informed about it, the more it can be shaped by the intervention of different parties. And we have the most wonderful example of that. Again, it's been cited again and again today. At our meeting today is the tipped wage. One of the many factors I would cite as the reason ultimately the omnibus worked out this incredible political solution was the fact that the Trump administration tried to jump a step of the regulatory process and ignore the economic impacts of that rule. And the law says, and the established practice is, that any major regulatory action has to have an intense cost-benefit analysis. Well, it turns out there was a cost-benefit analysis done. It just didn't make its way through the process. But that, along with a lot of the things, the mobilization we heard about today, was one of the reasons that ultimately it unfounded that. I mean, the notion that it was too hard to do. I'm amused by the fact that my colleague Heidi Shearholtz and her colleagues did this impossible task of enumerating the costs and benefits in about 2 weeks' time. And having known the capacities of the Department of Labor to do that work, and the dedicated people who I know were I'm sure doing that work, it can be done. And that the fact that that process was being jumped did not go unnoticed until it was brought to the attention by Ben Penn's wonderful reporting on that. In fact, the overtime rule is another example of that. What we did in the overtime rule ultimately was to go back to what was in the authority of the Department of Labor to say who is and who is not exempt by the 3 criteria of the overtime rule. And I won't, it's so easy to go into the weeds. We were so deep in the weeds on this. But 2 of the most important aspects are 2 characteristics that say who ultimately is viewed as exempt or non-exempt under our overtime laws under the FLSA. One has to do with the duties test, what you're actually doing. Are you someone doing executive, administrative, professional work? And secondly, there's this salary threshold, this idea, wedded still to the duties idea, if you fall below a certain salary, that presumptively, if you're getting that low salary, you are living in a labor market, you should have protections for overtime. And so defining that was not an easy task. It was certainly a very controversial thing we had to ultimately get through rulemaking. We did it through rigorous rulemaking. We did it through, Heidi and I spent hundreds of hours thinking about the economic analysis with a lot of the other folks at the Labor Department, and it went through the process. And I think it went through the process in a very inclusive way, bringing all the parties together in on that. We were already depressed enough in early November then to be faced in late November. The Fifth Circuit, Judge Amos Mazant, decided that we had gone too far in our rulemaking authority, that we had relied too heavily on the salary threshold in setting the rule forward. He stayed the order. Ultimately, I won't go through all of the backs and forths with the full district, 5th district, and back to him, but he threw the rule out. The interesting footnote, and it gets back to your question about how much should we fear, as opposed to, I would put it differently. The overtime rule and the tipped wage rule are both expressions of the need to be deeply engaged in the regulatory process, particularly at this moment in time. The Labor Department originally thought they wouldn't appeal the ultimate decision to throw out the overtime rule. One of the reasons the Department of Labor kind of pulled back, at least somewhat, was their fear about the loss of discretion to set the rule. Judge Mazant's decision was so broad, it kind of precluded rulemaking in any sensible way in the overtime space. And that means the Labor Department is now having to put out a new rule. My lesson from what we did with the overtime rule, and I think from these other examples, is we got to stay engaged. We have to be very much a part of the rulemaking process if and when the proposed rule comes out.
Well, if I can just put out a little commercial for ACS. We are engaging our members in a notice and comment process. So those of you who are members should be getting information about how to work with us. Our chapters, particularly student chapters across the country, are taking on specific rulemaking processes and organizing comments. So it's really vital that some of these big industries and the NRA among them, the other NRA, they're both bad NRAs, but the one in the and various others are organizing their own comments, and so those who care about worker rights need to be engaged as well. You look like you want to say something, Richard.
Oh, so I would just say that, so what this raises is there's sort of two threats. One is just a change of administration, and then new regulations. But the other one, which is the experience with the Fifth Circuit, is that you have a judiciary that will be increasingly hostile to the administrative state at all, and there's lots of now theoretical challenges to Chevron deference, for example, that are going to percolate their way up into the Supreme Court as personnel changes up there. And the Fifth Circuit decision looks a lot like this. And so one thing to think about is the administrative agencies at the federal level, what kind of power are they going to have, or leeway are they going to have going forward with a judiciary that's quite hostile to them? At which point you might, by necessity, need to turn to states and localities to do this, to the extent they're already doing it, obviously. But I think we're going into a stage. It's not new, but I think it's on steroids a little, of attacks on the administrative state, and that's then there are real easy ways for the judiciary to hobble the labor department, basically, and other departments too. Then you have a problem.
Right, and so at the state level, we jointly with several other state AGs, we submitted comments on both the OT rule and the tip rule. But what we're also seeing, this is just across, not just restricted to labor, we're seeing what looks like informal rulemaking as well, where the administration is just not implementing certain steps. And so everybody's reading up on the APA, and it feels very much like preparing for a new law school exam, because they are taking steps that look very much like major significant rule changes that should require notice of rulemaking. And so I think that's the other piece of this. So you have the courts, you have actual rulemaking, and then you have what looks like quasi rulemaking that should trigger the protections of the APA.
Sorry, are you done? Okay, so I had two quick things. One is I did a quick look at the rumored new, if DOL is, as we think they are, in the process of actually doing a new rulemaking for overtime, or they will set the threshold at a much lower level than the one that was the 2016 rule. That 2016 rule, DOL estimated, would have gotten new overtime protections to 4.2 million workers. If they change it to the rumored like low 30,000s, it will get new protections to 1.1 million workers. So the question of how vulnerable are workers, that means 3/4 of the workers who would have been protected under the 2016 rule will not be protected if they go through with the sort of rumored level that they're put at. So that's one thing. And then I just feel compelled to say this question, to answer this question of how vulnerable are workers. The other big thing is everything that everyone's talking about is absolutely the case. And then there's just also the fact that this is all happening against a backdrop of 4.5 decades of rising inequality, stagnant wages, and none of that is this administration going to do anything about. Any of the the whole host of things that have to change to start reversing that. They're doubling down on the rigged economy that led to all of those trends. So that's just the other piece.
Well, and so we're all really depressed now.
Sorry about
No, it's not your fault. It's not your fault. You're doing everything you can to save us from that. And you just made me think of, we had this wonderful panel of workers earlier, which I have to say is, a good reminder of how the worker-driven changes that help workers. And one of the workers in particular was a domestic worker. And one of the huge achievements of the Obama administration was the rule the fix, ultimately, to put domestic workers, home care workers, under the minimum wage and overtime rule. Can you talk a little bit about, and this is for all of you, because I think this was both state and urban. It was driven by worker advocates through different states who mobilized and built interstate coalitions, New York and California, Illinois, Massachusetts, great number of other states, and ultimately put something on the national radar that wouldn't have been there if it weren't for these mostly women of color, immigrant women workers, and it's so profound. And so how did that happen? What was how was it that the states and the federal government partnered in supporting that effort? And where does it stand now? Is it a target of this administration's regulatory rollback? And that's for any of you and all of you.
Well, I'll start. I think, and you outlined it well. I think it was not any one party, and as all good changes in social justice, it was the cumulative interaction of worker advocates on the ground, then working with politicians at both the state and the federal level, ultimately percolating to a moment where the administration was able to take the regulatory steps they could to move forward with that, and then a long process of fighting through the legal battles around the regulation itself, and then, and I mentioned it briefly in my remarks, the equally difficult problem of figuring out how do you implement this. Once we had put it in place, where you have 60% of home care work funded by Medicaid, the financing system of Medicaid and its capacity to support what then were the requirements for minimum wage and overtime for working people were very complicated and very different for a state like California and New York than it was for a state like Colorado or Mississippi. To me, one of the challenges it suggests, and it's still out there, I mean, separate from even the department or the administration's willingness to enforce the law as it exists, and it exists, and it's on the books, and enforcement is, if you look at the DOL statistics, the data that they do provide about closed cases, there are home care cases going forward. But there's a fundamental question out there, and that is we have a system of reimbursement, Medicaid reimbursement, that's inconsistent with creating policies that, never mind making that kind of work better, simply complying with the law is a challenge in localities because reimbursement rates are so low and because they're incompatible with what we have adopted now as national policy, which is people doing that kind of work should get minimum wage and overtime.
Anyone else? No. So, but just as a final, is anyone seeing any sign of a challenge? Is it so far so good?
Well, this went to the Supreme, so I mean, ultimately, the Supreme didn't take cert on the last appeal to the rule.
But I mean,
so that's
a regulatory rollback or anything.
I haven't heard anything.
Haven't
Right.
All right.
good news. Good news.
So moving on to another issue that probably have to start with you again, just because it speaks to the fissured economy, and that is the issue of misclassification. But this, ultimately for all of you, is this? So what can be done at the local level, and what would be our national response? Say that there was a labor department that was really interested in pursuing this at this moment. What should be on the agenda in the absence of a federal government strong engagement? I know you did a ton on it. So what should the next administration do similarly and more? And what are the states and localities doing that can help protect workers who are being called independent contractors instead of employees and not getting the full benefits of employment status?
Well, I mean, there's so many. Unfortunately, there's so much grease on the downward slope towards more independent contractors. It was added to it by the recent tax bill. Increases the incentives for people to reclassify employees as independent contractors, completely separate from all of the gravitational downward push towards those activities because of the way businesses are restructuring. I think more than anything, it is the time to continue to have this discussion about the importance of the definition of employment, about the fact that, in my view, the default in a labor market where workers are always going to have less power than employers, the default needs to continue to be employment. And this is why I actually love the definition that is embodied in the Fair Labor Standards Act, because it makes clear that most working people should be considered by that definition as employees. We have these state so-called handy laws that are out there where people are trying to presumptively make people independent contractors simply because they are dispatched through a digital platform. It's an absurd notion. It's counter to everything we know is the definition of employment, and yet this has already been adopted in 4 states, and it's being contemplated by at least 4 others. I think, I guess on the positive track, I would simply say we have got to put on the table the importance of basic employment protections as a foundational principle for organizing the workplace. Sadly, we're, I think, losing that argument right now.
And I would just say, as a note to that, it's not just the right to minimum wage and overtime, right? It's also anti-discrimination. It's everything else. So
workers' comp, UI.
Yes, exactly. So, ReNika.
Yeah, so I think we've taken, so I'll speak first in terms of our office and sort of what we've done to address this problem, and then just talk more generally about kind of a problem that we have of the exemptions and the workers that are not covered. So in New York, for the New York Attorney General's office, so we work as we are not the primary regulator in New York of labor, so we have a Department of Labor who is responsible for taking every complaint in charge. We have a bit more discretion in terms of what kind of work we're able to do, and so we try to use that to address problems that don't necessarily fit squarely in the existing statutory framework. And so on this point, we've worked, for instance, with the New York City Taxi and Limousine Commission to address undercompensation of Black car drivers and drivers, because the Taxi and Limousines Commissions, they actually are able to cover independent contractors and not employees. And so, using both the powers that we have as our office and working with state and local agencies that have sort of different jurisdictions to address worker problems, even where they are not necessarily covered under a legal definition of employment. And then we've also supported, so we submitted an amicus brief in support of Seattle's ordinance allowing for-hire drivers to organize who are not classified as employees and thus do not fall within the NLRA, and lending our support to those efforts as well. And then I think we've also, for New York State, we also filed a lawsuit against Domino's Pizza, which included both franchisees and franchisor, and we were able to include a state statute, Executive Law 6312, that allows us to go after repeat fraud and illegality. And so we don't have to take into account the definition of employ for that. So we were able to bring that charge against, or that claim against Domino's. So thinking about what the other laws are that exist is one of the things that we've been trying to do to get around this problem. And then more generally, I think, the history we talked about, the exemptions to the Fair Labor Standards Act, and, even how we define workers, from domestic workers and agricultural workers. From my work at LVF, we dealt with issues of prisoners and incarcerated people who are doing work. We've seen issues with immigrants in detention facilities doing work. And so just thinking about who are the people that are doing work and the extent to which they're covered, we've had this consistent problem, which is, I think, one of power. And so how do we try to create different fairness to address the gaps and who's actually covered? So those are the ways that we think about it, and don't have answers to the second part of my question, but we are mindful of those other workers who are not necessarily considered workers for various reasons.
I would just say that the industries move so quickly, and it's sometimes through ALEC, the Legislative Exchange Council, and so on. The ride sharing, before any of these cities were ready, I think 40-something states had preempted any local regulation of ride sharing, for example, like incredibly fast. So part of this is just, wow, and the handy laws I hadn't even heard of, and I've been watching this stuff pretty carefully. So they just move very quickly, and what it means is localities are always behind, and state level regulation is so important, and so you need some resources there.
Can I just ask a question? Especially for the lawyers on the panel, but under our federal laws, don't we take the employment definition from state law, which makes it very complicated in the enforcement? Or is there a federal standard of employment that pertains? Or can states set a different, can define differently who an employee is?
So I know for New York, we track the Fair Labor Standards Act definition. We also construe it very broadly. And most of the case law applying the New York labor law, which is the analog to the FLSA, adopts that language almost explicitly. So there's not much daylight between the definition within, in terms of the origins, which came first. I'm not sure about that.
I mean, I'm not a lawyer, as I should always point out to the beginning, but I pretended to be one during my time at Wage and Hour. One of the reasons I think the Fair Labor Standards Act, this idea of to suffer or permit work, is such a powerful idea, is it is not as much, many state laws on worker compensation, on employment insurance are based on common law principles. The economic realities test that has been used as the way to implement the definition in the Fair Labor Standards Act, maybe I like it because it is economic realities, but it is this notion, let's just look at what is this economic relationship. Let's not parse, are they controlling too much, too little? To me, it's so instructive. Just pull apart the economics. Ask the simple question, who's setting price? Who's setting standards? You know, the economic realities test has an important component. Are you in charge of for profit and loss? It's an economics 101 sensible question. And if you start pulling apart some of these business models, you know, I used to not be able to say it so bluntly, but it is laughable to look at a $70 billion company. Uber's whole value derives from the fact that they have a very powerful business model that makes no sense if you actually thought each of those entities was independent contractors making profit or loss decisions. It's absurd. And that to me is why the notion of rooting in this broader statement is sensible, because it leads you to ask this broad set of questions, including but not limited to control, to determine what are we looking at here. Because in a lot of cases, you know, you might look at it and say, yeah, in fact, those folks are truly independent contractors. They might live very precarious lives, but it is not part of the other business. I just think we have to get back to that basic economic analysis in making these determinations.
And I think you'll hear, and I am not taking a position because I am still in that role, but you know, I was listening to NPR last night, and they had the CEO of Lyft, and Valerie Jarrett was on as a board member, and the CEO was just sort of talking about this distinction or this choice between, when he asked about, sort of put with the question of not classifying the drivers as employees, as not that their drivers love flexibility, and there's sort of this false choice between flexibility and treating your workers as employees, and there are many employees who enjoy flexibility. And so I think we also should be careful to the extent that we think about, you know, a third option or a bundle of rights, that like that being an employee is not mutually exclusive with certain worker flexibility, and that many workers would choose to have the workers' comp, to have the UI, to have the anti-discrimination protections and the protections that come with being designated as an employee, alongside flexibility and not instead of.
One other thing that just made me think about, and we've already talked about the importance of transparency, but there's a lot of workers out there that actually don't know that their employer is classifying them as an independent contractor. They think they're on payroll. And so just if if they would get a stub that says, here's your classification and here's the justification for why, that would help both with, you know, then it reduces noncompliance from employers just being able to hide what they're doing. And it means that if workers want to pursue a claim, they have the documentation. So
it just reminds me, I was in my gym the other day in the morning, and there were a few women talking in the locker room about, you know, one woman was describing how she was a contractor for her company, and, you know, she had to work this number of hours, and she had to be available at this time, and she had to be responsible for all of these things. And, you know, and I looked at her and I said, Joe, I think you're an employee. But here I am in the locker room being your employment lawyer. But it's very true. It's hard to know, right? Your employer tells you one thing, and you got to go hire a lawyer or meet one in the locker room to find out whether you're actually entitled to employment rights. So let's talk for a minute about enforcement. And since you know, all experts at state and local issues, have worked in the Department of Labor and state government, sort of what are the strengths and weaknesses? What are some of the great victories? Where do we have a long way to go? And I know, David, you talked some about what are the things you don't like and the things you like about the Fair Labor Standards Act, and but sort of lay that out for us a little bit. What can states do better? Where do we need to equip them more?
I mean, I would say one of the things, again, I'm deeply proud of as part of a whole group of people who did this. I think we showed that you can do enforcement in the structure of the existing laws in a very different way. You can be proactive. You can think about how do you deploy investigators? How do you use tools? How do you ultimately think not about, to me, what we tried to change is not think about back wage recovery as the end, but it was really behavioral change. How do you create greater compliance given the resources that you have? I've had the good fortune to talk to ReNika and a whole group of states that have been coming together, comparing notes, thinking about how can states do that more effectively? How can we learn from the government, the federal government's experience, from different states that have a lot of innovative folks in AG's departments and in labor departments. But I think the capacity, I mean, look, the resources are always going to be woefully limited, even in the best of times relative to the challenges. But I think there are all kinds of opportunities, particularly in this world with more data, analytic tools that even allow one to even sharpen the way you discharge your enforcement authority to really improve compliance more comprehensively.
So I think for us, at the state level in New York, one of the key protections and advancements that I forgot to mention, but that we have a great criminal prosecution team, because in New York we actually have some criminal laws related to labor violations. So wage theft, retaliation are in our criminal code as well, and so there are criminal liability that we can attach to. And I have a unit that does prosecute employers where in treating wage theft as theft. And so, but even what we notice, in going into criminal court and with judges, that sometimes they don't treat it similarly and sort of think of, well, this isn't robbery with a gun, but the direct result of stealing wages from workers is that they can't meet the needs of their family. They can't make do. And so we really should be taking these seriously. So we've done that, and we are selective in terms of which cases we choose for criminal enforcement. We're looking for, New York has a pretty robust, some employers might say complicated, wage compliance framework, but that we prosecute cases where there is clear non-payment and or recidivist, an employer who has had problems paying workers in the past and really treating them. And we worked with USDOL on investigations involving Papa John's, where there were both civil investigations of franchisees and criminal investigations where warranted, where, the employer had two sets of books. And it was very clear, in terms of overtime and paying cash overtime, using two sets of names for workers to avoid paying overtime. And so where we see it, we do try to go after that. And employers treat it very differently when they're going to be charged with a felony or with a misdemeanor and are going to have a criminal record. So we use that as a mechanism for deterrence. And then we also generally think about how we can amplify our resources. So I mentioned working with USDOL. We now in our office have a research team, which is a team of data scientists who are able to handle big data. And the head of that group comes from a labor background himself, and he's been able to give us ideas in terms of thinking about how we identify violations. And so how we can use kind of the data that employers have to be able to increase do more with less, and be able to do that as well. And so those are some of the ways that we're thinking about, but we still really struggle with industries where the workers are isolated or underground, and we don't have we don't have the staff to kind of blanket the workforce. So we really do need at least some either worker organization or group of workers who are somewhat organized themselves and are able to do that. And that's, I think, where we still struggle.
Well, ReNika, I was just going to say that when at ACS, we did a convening of AG staff from the labor or who work on labor issues with Sharon Block and her center at Harvard. And the New York Labor Bureau was such a leader in that discussion about how to speak to communities that feel vulnerable, and particularly undocumented workers, how to get them to come forward. And so I wanted to give you guys a big shout out for that, because I think that, is one of the big challenges is the workers who are most in need, as many people have said, are the ones who are also the most afraid or are the least informed. And it was just the other AG's offices were, taking notes about what New York does to develop relationships. So I'm going to ask one more question, and then we are going to go to Q&A. But just, Richard, just to get back to preemption for a second, if that's okay, and any of you can make any closing statements you want. But so we talked about some of the negative impacts of preemption. What can we do to stop it? What are the cities doing to fight back?
Home rule. Everywhere I go, I say we need home rule. So I think this is a political fight. It's not a legal fight. There are some states where there are some tools to resist preemptive legislation. Ohio's pretty good at this, but most other states, even with existing home rule grants in state constitutions, which many states have, they still permit ample room for the state to override local legislation. It's just general laws trump, and we see this in sanctuary cities, environmental protection, plastic bag bans, as well as labor and employment, obviously. And so you need, the cities have to do a couple of things. One, they have to join together, both intrastate and then across the nation. And some of them have done that. Environmental law is one of these areas where they've sort of joined forces. And then the metropolitan regions, in which are our biggest labor markets in these places, have to assert more power. And there's some tricky political questions about how you do that with the central city and the suburbs. But our economy is really a metro area economy. All the production is happening in large metropolitan regions with cities at their cores. And cities have resurged in the last 20, 25 years. There's still obviously lots of poverty and inequality in our cities, even more so because our cities are richer, actually. So leveraging that economic power is a possibility and something that cities have sought to do and need to do more of. But the legal response is a difficult one. There's an equal protection kind of response, which I think is a tough one. And then there's state law responses. There's also what localities do is they assert federal preemption on their side. That's harder to do in the labor context than in some other contexts. They did that they asserted that in immigration in Arizona. The court wasn't that happy with that. So it's hard, but I think one of the things that I would just say, just to conclude, as progressives, we often look to the central government, the federal government, to save us, if I might put it that way. And I think the risk with that is neglecting the state and local angle on this. And I think in particular in the foreseeable future, the local angle is going to be where a lot of progressive legislation is able to come out of. And so maybe shifting focus politically to that is one possibility.
I know we have the audience is begging to ask some questions of this great panel, and I see a hand right there. So we'll start with you.
Excuse me. Thank you. Yeah, speaking to the local aspect of getting more progressive laws, I just want to remind everybody that gerrymandering splits up homogeneous progressive areas. My sister lives in Dallas, and it's one of the blue areas of Texas, and nary a progressive from that area. They've split it up like a pie, and I've seen it in all my years. It's an important factor.
It's called cracking. Jules. Sam, hit that. Here comes the mic.
Thanks. I think one point that or a couple of points I'd make are first, if the federal government had used the criminal provisions of the Fair Labor Standards Act over a long period of time, it would have had a very substantial interim impact on employers. But that didn't happen or hasn't happened. Maybe New York is doing it, but in the federal sector, those prosecutions have been few and far between. I know it's tough to get the U.S. attorneys to pay attention to this. Put it this way: if you steal a pair of sneakers at Walmart, you can go to jail. If you engage in stealing your employees' wages, your profits go up. And next time around, I think a little more criminal prosecution coming out of the Wage and Hour Division or initiated there would be very helpful. Secondly, I haven't heard anyone say anything about the impact of the private bar in enforcement. There are literally thousands of lawyers across the country, including me, who have been litigating Fair Labor Standards Act for a very long time, cases for a very long time. The National Employment Lawyers Association will have its convention in Chicago late in June, and I have the program here, and FLSA is one of the major subjects for about 3 or 4 days. And I know Joe Sellers is here, and he clearly is one. There's some judge trying to hold Joe in contempt, as you may have heard. He might talk about it later in connection with the Texas situation. And these lawyers have spent a huge amount of money advancing FLSA principles across the country. And there needs to be greater coordination between government and private attorneys on FLSA enforcement would be my point. For example, the National Employment Law Project, NELP, has a listserv which we FLSA practitioners ask questions on and get answers from our peers. So I would say the private bar is not to be ignored.
Can I just say Chris Owens is on the next panel, and Joe?
Yeah,
Well, why don't we just go down there?
Wait.
Well, why don't we just go down? I think everybody wants to respond.
Gotcha.
So I have to first tell an anecdote. My first day on the job, I've known Jules Bernstein for probably 20 years. My first meeting I was at, and I was just trying to figure out my life. In fact, I remember Joe went over with me to a convening by NELP and a bunch of other groups that I think Kathy Ruckelshaus has put together. And I gave my speech, and the first question came from Jules. And I don't remember exactly what it was, but it was a tough question. I was like, really, Jules? You know, that's how you're going to start? You know, I agree with could we have used the criminal tools more? I would say yes. Did we try? Yes. Where we used it particularly were in cases involving immigration and particularly where there were egregious acts particularly because of someone's undocumented status and threats and using it in that venue. But I agree, it's a tool that could be used much more expansively. And quite frankly, if I had to do it again, we would also use our civil monetary penalty. We used it a lot more than prior administrations, but that's another one that we could use much more extensively. But your second point on the plaintiff bar, I totally agree with. I think, I think we would all agree with that it is a natural complement. It is a huge part of what ultimately makes employers more comply because of that threat. It was why we could do more proactive investigations, partly because we knew that people had private rights of action, either individually or collectively, and that is a huge part. And I also agree with the general point you're making of greater coordination between those forces and strategic coordination, I think could be quite powerful.
You can go. Are you?
So agree, and my first job after not clerking but after clerking was at a plaintiff side firm, and so firmly believe in co-counseled with Joe in another life. So I think there's absolutely we sort of assume, certainly at the AG's office, we assume that the private bar is going to cover much of the ground, and that what we want to do is be filling the spaces where the private bar cannot or economically it doesn't make sense that we can do that to provide the most ground cover, if you will, for the problems that we see. And in terms of the criminal prosecutions, I will offer one caveat that, you know, just because of the difficulty in establishing a criminal case, we often use it too where the employer is the known entity. Like, we don't want to be prosecuting a manager, when we know that the money behind it is sufficiently removed from the operations, that criminally speaking, it's just much harder to hold them criminally liable. But absolutely, I think that there's, the work between the private bar. We have a fairly good relationship with the private bar in New York in terms of making that case.
I was just going to make a tiny point because I am also not a lawyer and I never actually played one. But the thing that the stacking this, the discussion of wage theft as criminalizing wage theft seems so, when we run the numbers for this, low-wage workers lose more than $50 billion every year to wage theft. You can stack that up, and I wish I had the numbers in my head, and I don't, but we have in the past stacked that up against the total amount lost to burglaries or the total amount lost to robberies, and it actually dwarfs it. So when you think of the scale, it's totally appropriate. And then the only other thing I was thinking about is just thinking about this DOL, and instead they're instituting this sort of wage theft amnesty program for workers. That is, they have a new pilot program that will just allow employers to pay back wages if they do it themselves and avoid any penalties. So this whole idea of deterrent, it's just like cutting off any deterrence right at its head.
Yeah, we've been charging it as grand larceny. Because that's what it is.
Yeah.
So I think we've run out of time, unfortunately, because this panel, at least from my perspective, could go on for several more hours. It's such a great discussion. But I want to thank this great panel. If we could give them a round of applause.